All right, so thank you everybody for joining us today. I know we're going to have a couple more people jumping on probably in the middle, but I'm recording so that the folks that are not here can go back and watch. And I'm really pleased to have Darren Welsh. He's our Berkshire Hathaway legal counsel for all three markets. And I wanted him to go over today the new laws for California. I know we're already halfway into February, but he's got a good handle on all of that, and maybe also go over some case laws that might affect us today. So Darren, I want you to start the meeting just in case you've got to go after you're done speaking. So thank you again for joining us.
Anytime.
So I'm going to go ahead and put up on the screen which one do you want me to put up?
This one.
Okay, this one. This one?
The short one, the little guy. Not the big, yeah, there.
Okay.
Hey, so thanks for having me. I've met some of you, not all of you. It's always a pleasure. You guys are, is it cold there?
Nope. No, it's okay. Like, well, it's going to be almost 70 today, so it'll be nice. Okay. You look like you're cold, all bundled up.
Yeah. Mark always makes fun of me because I wear a scarf in the winter. Well, if you live in Vegas or where you guys, I mean, my blood is about as thin as like water. So I had family that moved. We all grew up in Nevada, and then we moved all over the place, Chicago, and for school and what. And I would go visit and just be like, holy smoke a rollies. I cannot do well with the cold, but I don't know how they do it. I feel bad.
I'm glad we're not in Texas right now, aren't you?
Yeah. I don't know how they do it. I mean, I'd be in the same boat. I'd be like burning furniture in my fireplace, Hey, so let's get, what I want to share with you guys today is CalBRE did a wonderful, they reduced down all the laws that came out of the last legislative session and the ones that really affect real estate. These aren't really going to be, the new laws are not necessarily directly affecting our resale of property. But because we're in real estate and we deal with humans, and humans buy real estate and they get divorced and they die and they want to save on taxes, etc. And they rent properties out and they live in common interest communities, common interest developments. These are all good things to just know, kind of like in the back of your mind, because it's just going to basically, it is the fabric of our society that we deal with, okay? And the biggest one is Proposition 19 on the first page here. And what I did for Shannon is I took the CalBRE entire write-up that they did. It's like 65 pages. And all I did was number the bottom because they did not number it. I didn't change any of that, but I just numbered it. And then in this one here, which is I think like 3 pages, I put the page number. If you want to read more on a particular law, like the home hardening disclosure, the defense of house fire disclosure, that's more in depth in the 60-page document. But it's great because of email and whatever, an electronic PDF. We don't have to print all these things and mail them to you. You can she can email it to you and you can take a look. But I did like a reduced version on this one. In the back of this one, it's even more reduced. But like I said, if you want to do more reading, you can go to that bigger 60-page document. So the first one is Prop 19. This is a change that for tax purposes to keep your basis in the property that you own now, and then be able to move it to a new property. So CalBRE really got behind this. This is probably going to be, I call some of these laws kind of sleepers, or they're kind of like a flywheel that will slowly get going. And this is going to be a very effective tool for persons that are, this is owner occupied and moving within California. So if you're over 55 years old, which is so far away for some of us, I mean, for me, that's like 90 days from now, so I don't know if that'll even happen to me. But you're 55, and you've got other exceptions, like if your property was substantially damaged in wildfire. But let's just keep it simple. You're 55 years old, you sell a house, you can, sorry, I don't have anyone else here right now. I don't want this to ring. You can sell your home and keep the basis of your home. So if you bought a house in 1985 for $300,000 and it's now worth $800,000, what's your taxes? 1% of 300 grand per year. You can keep that basis of 1% of 300 grand moving to a new property. And you can, most likely, you're probably, you know, your property, maybe it's worth 800 now. You're probably you could even buy something less than 8, or you could match it at 8 and downsize. You could say, well, I had a bigger home, my kids are gone, and I would no longer want to deal with a yard the rest of my life. And so I want to live in a community where I don't have to mow the lawn, or I live in a condo, or you're in the city and you want to go to the country, or you're in the country and you want to live in the city. You can make that switch. You can do it anywhere inside the boundaries of California. So you can leave San Diego and go all the way to the north, et cetera. So this is something that's really just going to inspire people when they start to learn about it, because in a sense, when you buy a home, you did the right thing and whatever, and then you go to look into new properties and you check what your costs are going to be on a monthly basis. You say, oh my gosh, that's a bill I don't want to deal with. I don't want that 1% on the higher number. This will keep you in the lower tax bracket, which is kind of amazing. And what they did was they kind of, and this effective April 1, so coming up, right? And there's a line in the sand. I'm getting a lot of questions. Well, I sold my house last summer. I sold my house 2 weeks ago. Do I have this ability? I don't think so. But write on this memo and you can go deeper into it. There's going to be more and more discussions with tax consultants, et cetera, whether or not there's going to be any type of exception for transferring title, you know, today, and whether or not you could take advantage of this. But like all changes, everything, we're in a, you know, you're in a topsy-turvy period for a bit, and then it'll just clear up. So as of April 1, over 55, we're going to have this, you're going to have this ability to save this money. So I think this will really help a lot. Where they took away from it, because you know how tax bills are, they do one thing and they take away another one, right? Like when last administration, we had taxes lowered, but then your taxes kind of went up if you lived in a state that had high income tax, because you used to be able to write off your local income tax on your federal taxes. They took that away. So in the bargain and exchange in this one is that it's not as easy now to make the transfer to your children. So you used to be able to make the transfer. Your kids moved into your house, bought your house from you, had to own or occupy it, couldn't be a rental. And my guess is that really wasn't working. So on a modern era, our kids are really not moving right back into our houses. And I think that maybe was the case 10, 20, 30 years ago, but that's not really happening anymore. Maybe we're living longer, or our kids just don't want to live in the house that they grew up in. I don't know, but they made it easier for 55 and older to basically transfer that home into some other neighborhood that they want to live in now. So this is going to be great for us, and it's brand new. There's going to be all types of you know, changes that come to this and whatnot. So that's probably the most important one. The next one on page 14 is the home hardening disclosure. This has all to do with fire. There's another section on this too later we'll talk about. But this is for designated high fire areas built before 2010. So this is not a new law. This is mostly an enhancement of what was going on before this disclosure. If you sell in Big Bear, for example, this is going to be important. It won't really affect us too much. It just is going to depend on where your listing is. Like I said, if you market in high fire hardening, designated high fire areas, this is part of your life already, and it's going to continue to be. So we're going to see a couple of different changes that are happening as a result of fires and floods, etc., and disclosures that are going to come about. Okay, insurance, and where this is going to come up is we're going to have the disclosure, and it won't really matter, but you're going to probably see some pushback or complications with escrows, even cancellations, because of it'll be a third party coming in and saying, we want to look at your home hardening disclosure. We want to talk about the home. It's going to be the lender, right? And it's perhaps going to be the appraiser. And this is just, we always evolve, right? And in our industry, we're going to see insurance affecting us little by little, more and more and more. Insurance, homeowners insurance, and special insurance. We already know that flood is a nightmare because you have to get it specially from the feds. But getting insurance in high fire areas, closer to water, etc., it's going to get more expensive. And I put a little note in here. I heard this on the radio, and I went and looked it up. And I found this quote for us. To be a disaster in the United States, an occurrence has to cost $1 billion.
Oh.
So it's like, oh, we've had a disaster. That means more than $1 billion was spent on that hurricane, for example. Okay, on average, we have 9 a year in the United States. So we have 9 disasters over $1 billion. In 2020, we had 22.
Oh, wow.
So we went from 9 on average to 22 disasters just within our continental borders, right? That's a lot of insurance being spent, and that's going to mean that that cost is going to be spread slowly but surely amongst us all, right? And so that's why things like the home hardening disclosure are sort of going to dovetail back into, well, we already talked to the buyers through the forums, et cetera, that they need to look into homeowners insurance, but we're actually going to have, I don't know if you guys have experienced this yet, but we already are having in the high fire areas where the insurance can be granted, but it's low, or sorry, it doesn't cover certain things. So you can have insurance for this and this and this, and they won't insure you to rebuild your house, which is a big factor. I was just reading an article on a musician who was going to build some musical compound, you know, outside of I think it was north of Oakland, and he decided not to do it. And last summer, the house burned to the ground.
Oh my
So
God.
he was talking about how they would have been there with no insurance, right? So moving on, this one on page 4, it's also listed on 38. I don't know why, but this one is another like sleeper. It doesn't affect us directly, but this is a big deal, and I think it will be a part of our life on many, many, many times, even our personal lives. So what they did was they made all common interest development mandatory to allow rentals at a minimum of 25%. This is a big deal. So if you live in a common interest development, it's a private contract, and as long as we don't tread on a protected class, then you are unlimited in what you can do. You know, owning a boat and parking it in your driveway is not a protected class. So you can easily say no parking on the street. You can say RV parking has to be out of sight. You can say any number of things. I mean, there's certain crazy rules. You have to be able to display a flag and, you know, certain things like that. But so what we could have, like now, you could be living in a CID and it says we only allow 10% renters. And everybody agreed to that because they got the bylaws passed. They did the adequate number of votes. Just imagine it was done perfectly, right? Well, that's changed. That's been overridden by the state legislature, and now it bumps up to 25% automatically. And so this is creating housing. It's creating opportunity for investors, and it's basically giving a little bit more inching towards people being able to buy in that neighborhood and being able to rent it out. So if you live in a CID and you have a limit of 20% or something, that just went up to 5%.
Nice.
So this is going to resonate slowly but surely through the communities, and it will change a lot. And then most importantly, the same law says if whatever your existing rights are, they can't be changed. So right now, if you live in a CID and there's no limit on renters, and they were having a meeting today, and they've been working on it for 4 months, and they were about to put in some sort of limitation on how many renters could live in the community, they can't do it. Because if it's 100% right now, and they say, well, we're going to lower that to meet the law of 25%, you can't do it. Because you can't lower what you already have. So that's another one that's going to be a sleeper of like, you know, they're going to go and look at this in 8 months and say maybe somebody was working on this. So you will, if you hadn't already had it in place, that there's a limitation on renters, you're not going to be able to, that association is not going to be able to make that change. So that's kind of like, to me, it's a big bomb that got dropped on the whole idea. I mean, some of us live in those communities. We know what that's like. I've had a couple of cases over the years where we sort of screwed up because we, you know, the classic example is we sold to someone who was going to live there. They got the opportunity to buy at this time, but there, in one example, she was a teacher. She needed to live in a certain jurisdiction to have her job, and she was about to retire. And then she was going to move to this other house. And she went to put a renter in, and of course the association came over and said, you know, we're capped out on renters, so it's a fine of $1 million a second if you put this person in right now. And that of course caused great anguish and whatever, and you know, everybody was very upset, and we had to work that deal out. And so that's where we get tagged indirectly, because we don't realize, you know, we say, have you talked to the HOA, where are you going to live in? And then they tell us later, oh, I'm actually going to rent it out for 2.5 years until I retire. And we didn't know that. And then there was a restriction on the amount of renters going in. So that will aid, that this is going to aid, it will aid those persons who are, you know, leapfrogging into retirement, for example, or about to move there later on if something else happened, their kids move out or whatever. And as I say that, I'm realizing if you don't live there yet, you don't have any rights. So I wonder if they can then put a moratorium in on the percentage for future owners, capping it at 25. I don't know, but this is going to be something that will, I think it will actually help us, because in that it probably will move the needle more. So persons will have more flexibility of living in the home and leaving it, renting it for a while, et cetera, et cetera. If anybody's ever had to deal with that cap, it's quite a nightmare, because there is no reader board, right? You can't walk by the HOA and say, oh, today Bob's tenant moved out, everybody, so we're at 24%.
I was just going to
really
say,
hard
how
to know.
are they governing that? Because sometimes people just decide to rent their place out. They're not going to tell the HOA.
Right. And then what happens later is, my door just opened, so I was seeing, I don't know if there's a, you know, serving a warrant on me or whatever. I'm joking. One of the first things I taught my kid to say is if the doorbell rang, he said, get a warrant, when he was like, when he could first talk. We thought that was really funny. Now, not so fun, right? As he's older. But so that's going to be, like Shannon said, it's really hard to know. It is really hard to know what that ratio is. HOAs sometimes are very good at keeping up on that. Sometimes they're not. And then you, of course, get the HOA coming back talking to you later. And, you know, you've already bought the house, you've got tons of money into it, and they're telling you you can't rent it out. I mean, it's just truly a rock and a hard place to be. So moving on to page 28, this is another fun one. Doesn't really affect us, but it's good to know. And that is, when you foreclose now in California, there's a new level of bureaucracy. A tenant has a 45-day window to match the sale of the auction price. So in this market, it's not going to matter. In the Great Recession, we had a number of foreclosures that occurred, and there were so many of them that there were so many of them that it was hard to keep track of all the foreclosures that were occurring. And an auction could occur, and that home sold at auction for maybe 30% what the market value could bear. And that's why investors are down there. And for whatever reason, the bank didn't do a credit bid. They didn't care about it. They wanted just whatever money they could get out of it. They didn't want to deal with it anymore. They didn't want it to turn into what we call an REO. And so sometimes you had quite the bargain occur. Well, now, if the property is occupied by a tenant, then they have to contact the tenant and give them a 45-day window to match that price. The odds of this occurring are going to be pretty low, but you never know. You know, if you're living in a condo and they call you and say, this just got foreclosed upon and it went for $350, you want it. And they say, that's amazing. Condos in this unit are going for $450. They have a 45-day window to do that. So again, it doesn't affect our direct resale, but this is just fun stuff to know that's going on in a real estate environment, right?
I'm sure there's going to be some other kind of stipulations too, that, you know, if the tenant like leaves the property, are they still going to be allowed to have that option? Like,
Well, if all leases run with the land, and so
right, okay.
if it is leased, they would continue to live there through the life of the lease, right? But someone asked a great question the other day, is they say, what if I lease it to myself and I get foreclosed upon? I said, well, I think if you separated it enough and you had an LLC and you weren't even the owner, I don't know, maybe, but this is going to be, again, I think a lot of these things are trying to figure out ways to keep people housed and make sure that, you know, people where they are, they stay where they are. I don't know. Also, nonprofits are given an opportunity. They have to find this out on their own. They're not going to be notified. But nonprofits are allowed to do the same purchase. So that's just another fun fact. I mean, give me a break on trying to understand that, why they did it, or you know, being in a perfect scenario where you're a tenant and you want to buy the very home that was just foreclosed upon. Could be, it could be, could happen. So we'll just have to wait and see. Isn't this fun though? They just make it so exciting, right? I mean, we could be brain surgeons or something. That'd be so boring, but no, we get to be in real estate. Moving on, we have the rent moratorium. This is a good one because it already was updated when I first wrote this, when CAR first came out with this. The second part here of SB 91 just came out a couple of days ago. So did I do your meeting on where we're at with rental rights in California?
No.
No. So let's start from the beginning. There's two tranches in California. There's last summer and there's now. Last summer ended September, and then we moved into the second tranche. First one, last summer, you don't pay your bills. You cannot be, if you were affected by COVID, there was a blanket moratorium on non-payment of rent. So you're affected by COVID, you can't pay your rent, you can't be evicted. You still owe the money, but you can't be evicted. So that's the big key to tenancy in fighting for evictions. What the thing about landlord-tenant evictions is, what you're really arguing first and foremost is occupancy. The money, sometimes you can get a judgment, but not always. Most of the time, the first agenda is occupancy. Can I take possession away from that tenant? Or as a tenant, can they take possession from me? And so the first tranche said, you cannot be evicted, lose occupancy, lose possession because you didn't pay your bills. You still owe the money, and that money has to be pursued at a later date, which is March of 2021. They did this last summer. Then it changed. September 1 came in, and they said, okay, now we're in our second tranche. So you have to pay, if you're affected by COVID, you have to meet the criteria, you make 100,000 or less, you're financially damaged, you have nowhere else to go. Now you have to pay a minimum of 25% of your rent in California, or you can lose possession. If you pay 25%, you're going to keep possession, but you still owe 75% of the rent. That debt is not forgiven, just like the debt that was not paid in the summer. Now you can be sued for that rent only. You can't be sued for possession, okay? Second tranche has been extended twice now, and we've moved all the way to June 30. So the 25% minimum rent for folks affected by COVID now can stay all the way through the end of June, pay only 25%. That money that's owed effective March is going to be able to be pursued in small claims, and small claims court temporarily has been modified. We have a cap of $10,000 in California for jurisdiction. 5 months ago, you sue somebody for $10,001, you cannot be in small claims. You either have to waive the rest of the $10,000 and tell the court, I want to only pursue up to 10K, or I have to move to a higher court. Well, now they unleashed the cap of small claims. It's unlimited when it comes to the subject matter of pursuing rent. So you could have a tenant that owes you all the way back in April, you know, $2,000, $2,000, $2,000, $2,000, $2,000, $2,000. It goes past 10,000, and you're going to see landlords pursuing tenants in small claims without attorneys. No lawyers are allowed in small claims in California. So it's going to be, I think it's going to be a great reality show. I think we should just set some cameras up, get in there, and just see what happens this summer. You're going to have guys going in there and arguing over $50,000. You know, it's going to be absolutely bonkers, right? And then you're going to have tenants that get a judgment against them for 36 grand. They have about $1,400 in their checking account. It's going to be a disaster. So, but that's where we're at in California for non-payment of rent. It all comes down to ability to take possession or not take possession. And all that money is lifted up and moved away from the subject matter of possession, which is a brand new way to look at it. And technically this would expire June 30. We don't know if it'll be extended. Many of these bills have been extended automatically right as we get close to the final hour. So what we're going to deal with here is, you know, how is the vaccines going? How is the infection rate going? If it goes down, we're going to finally get a grip on where we're really at. And so because we really just don't know the state of landlord-tenant law right now until we get past this June 30. To mix it up even more, we have another federal overlay called the CDC moratorium, which is different from the California state one, which is federal from Minnesota all the way to here. Everybody's under this one. It's similar, but it's even more controlling. Has nothing to do with money. They don't care about 25% or anything. Evictions are simply not allowed if you sign the CDC declaration, says you make under 100, you're affected by COVID, you have nowhere to go, you're going to be homeless, or you're going to move it into a more crowded home. So basically the 4 elements. And that one's even more confusing because we don't have a lot of direction on it, meaning it is unclear. Look at the 25%. You can go in and talk about the 25%. And in the California rule, you can say they make more than 100,000, therefore they don't fall under the requirements of the California second tranche. CDC came out and it didn't really clarify if you could argue or have a position against the tenant, or the tenant makes the declaration. Is that the end of the conversation? We don't know. So it's going to depend on court to court and personality to personality. But right now, we have the CDC moratorium, which affects the whole country. That goes till March 31. That is a complete wet blanket thrown on the concept of evictions. And as long as you make under 100, you have nowhere to go. You can state you are not going to be evicted, and that's going to be that's basically what's happening in an eviction court. So you look at it from right now, we have 2 worlds. March 31 is going to be a big deal in the landlord-tenant law in California. If the CDC does not extend their moratorium, okay, that makes it a lot easier to understand. We take that whole variable and we put it away. If the CDC extends into the summer of 2021, it changes the whole game plan, right? So we're waiting on that date, and we're just going to see what the CDC did. The CDC is an independent agency. It's not coming from the prior administration or the current administration. It's a health directive. It's kind of like a wartime act where they just jump in and do what they want to do without any authority given to them, previous authority. So the organic authority comes from Congress when they created the health agency, which we never heard of until this pandemic, right? It's like CISA. I never heard of CISA ever in my life. CISA is the one that is the executive, the enforcement branch of Homeland Security. That is the one that came out in approximately April and said we, as real estate agents, are essential. So it was that agency's ruling that allowed us to go to work and say we're essential. We have to go be on the front lines, which was very confusing in the first 60 days. I never heard of CISA, right? And so whether or not the CDC is going to push that button and extend on March 31 is a big variable. We just have to wait and see. Because if they don't extend and California doesn't extend, then we will be back to normalness come July. And there'll be a landslide of evictions that are going to occur. Now, the state government and the feds are both have programs for landlords and tenants to help them pay their bills. And I noted here, part of SB 91 is a state rental assistance program. This is for both landlords and tenants. If you have a tenant or a landlord that is, commented that they're panicking because they don't have enough money, whatever, they should pursue this. And this is one of those things, it's such a moving target. We just have to wait and see what the current federal administration is going to do. Because we have a serious dilemma in the United States in that we took millions of people and we told landlords we need you guys to hold on to them for a bit. We don't know where to put them. You take care of them, and we're going to get back to you. And now we've got people who potentially have not paid their rent since April of last year. So if you're a landlord and you are a mom and pop shop and you own one rental, or maybe up to 3, and you are needed that rent to pay the mortgage, and you're planning on your building wealth and you're moving towards your retirement, this is devastating. You're easily going into a year plus of no income at all on that property if they've qualified under the CDC rule. So if you think about that and then you extrapolate that and move it out to millions and millions of landlords throughout the United States, it's a major problem. So it's a hot topic that everybody is talking about, and we'll just have to pay attention to what's going on. Okay, the third page, we've got a couple of easy ones. They're just, again, not exactly directly related to us. One of them is if you're over 65, they've moved the date to be able to cancel a real estate lease, not a sale, a lease up to 5 days. It was 3 days before, now it's 5, right? And then on page 11 is the translation law, which is, translation law was utterly incomprehensible before, and now it's even worse, which is great because it's all about translation. So, it's basically translating into no one understands it, right? And this rule in California states that if you are negotiating in one language only, all the documents have to be in that language. And it used to be that the signer had to get a copy, and they've expanded it. So now it's persons who didn't even sign, but all parties that are affected by it. So you have scenarios sometimes where husbands and wives, spouses, don't have to both sign, but they're both responsible for that contract. Now all parties responsible would have to get a copy of the translation. So this is a nightmare, and this is not something that we deal with. So when we are negotiating, we do not negotiate in one language. We have to always figure out a way to get it pushed back to English. We have a form on CAR. We have the translation form where the party tells us who their translator is, and it removes our liability and moves it off to the friend or family member who tells us that they've been communicating with the client of the information that we've been sharing. They're reading the documents to them, etc. That's a great form. That's the form we use because it's not possible for CAR to put every single document into Russian, Chinese, or whatever. Not possible. So this is just something that we move away from. I don't even know when this law would ever be truly in effect because you'd have to have a contract this big, right? That's the only way you could do it. I mean, I don't even know what it would be for if you're renting a kayak or something, But in real estate, it's not possible at all. So we move away from that. We do not negotiate. So if you're talking to your client in your language that's not English, you have to figure out a way to not do that. And you have to bleed English back into it somehow, some way, and use the translation form where we get the client's friend, family to assist us, okay? The next one is the RTDD. This is about, it deals with probate and transfer of title upon death. This is a unique form to California, and it was a rule, the revocable transfer on death deed. So it's actually a great tool for probate. So when we own real estate, if Shannon and I own real estate together as an investment and I pass away, my estate would get my half of the house. That's tenants in common. If Shannon and I own property together and we wanted to be joint tenants, then whoever dies, their half goes automatically by law upon death, upon the recording of the death certificate. Actually, the transfer occurs even before it occurs. It occurs immediately upon death, and then the transfer of title is done later, but for liability purposes and taxes and whatever, it's immediately upon death. The other half of the joint tenancy owns the property, right? Which is where you see, where do you see this? Spouses, boyfriend, girlfriend, you rarely see investors doing this, but it could happen. So what the RTDD does is it creates a joint tenancy scenario. And so what you've got is, I could own a home and I can fill out my RTDD and tell anybody I want to get it. So I don't have to probate it into their name. Cool. All you do is record the RTDD, and then it says, my kid gets my property. I don't even have to have a will, right? And so this law has been used a lot. It's a probate tool. You've got, it was set to expire, and it was one of these laws called the sunset law. So they write these laws and they vanish in a couple of years. You know, most federal tax bills are sunset laws, meaning they put them into play and then they only are there for like 4 or 5 years, forcing the government to go back in and talk about it again. So this was set to expire. They extended it for 1 year again because they like it. They want to make changes to it. They ran out of time because of COVID.
Mm-hmm.
So again, doesn't affect us, except you may get a listing and the person says, what happened? It's like, well, I got this house last year from my mom. Oh, did you probate it? No, it was just transferred automatically. Oh, are you on joint tenants with her? No. But they said it's my house. And it's like, oh, that doesn't make any sense. You should normally probate that. Well, if it was an RTDD, that's how this happens, right? And of course, you would run it by title and make sure everything's okay. And if you think about how awesome the power is, I mean, if you have kids, you can hold it up and, you know, next barbecue and say, I don't know when I'm going to go, and I don't know which one of you is going to take care of me best in the next summer, mow my lawn, pick up groceries, you know what I mean? I kind of want my house painted. And then you can sort of wave that around and work your family into a frenzy of who's going to treat you the best over the next couple of years, build a little, you know, camaraderie there. And and you know, you can re-record one of these on a weekly basis, depending on who's your favorite, which I like that, right? This could be another reality show, just called RTDD. Right?
I heard this with this. I remember when this document came out and a title had said what a nightmare it was. I had completely forgotten about it, honestly.
Mm-hmm.
So
it's still out there.
1 more year.
Yeah. So, and if they get it honed in and we know about it, it's quite a tool. If you don't have any other assets besides a couple of bucks in the bank or something, or you figured out a way to get rid of your stocks before you pass on, you can avoid probate by filing one document, which is, you know, pretty good. We do a lot of probate. We do a lot of probate where the property is left to the children, and we get involved because we're in the middle of selling it during probate. We make it subject to court approval, which is a nightmare because people don't understand that there's an automatic auction at any probate. If you deed it to your kids and they get the title during probate, that's fine. But if you want to sell it during probate and you just want the proceeds, which is quite common, because many times the heirs don't want the house. They just want to divide the cash up. And so that forces us to get a sale on, go to probate. Somebody else can show up, bid higher. You have to tell your buyers to be present. You actually have extra penalties if you don't close on the probate sale. You don't just lose your earnest money. It's built into the statute that you can be penalized, and if the estate loses money, you actually have more damages. So probate can be just a nightmare. Okay, moving on to page 24, you have the defensible space surrounding. Similar to the form we talked about the other on the high fire hazard area. So again, this is for specified high fire hazard areas. This is about building a perimeter around your house and making it, this is a work in progress. And this is going to be, again, go to a fire area, and it's going to be, have you cleared enough debris around your home, and then disclosing that you're compliant. So if we're selling in that area, this is going to become vocabulary that we're very used to. We're going to lose escrows. We're going to have arguments during escrow over an inspector. Probably in the future, we're going to have a cottage industry that comes up, and the inspector in that area touches on the defensible space surrounding. And they're going to announce you're buying a home that is not compliant with the defensible space. And then the insurer could come in and say, I won't insure this house. Or the appraisal could come in and say, this has a pine tree from 100 years old. It's 2 feet from the property. And that lowers the value because somebody's got to get rid of that tree. So this is a work in progress of dealing with the fires. And there's no way to say what it's going to result in or how much it's going to affect us. We just have to play. We just have to get in the field, play with it. We're going to learn about it, and it'll as always, it will work itself out. And realtors always take care of everything. I mean, we're the ones who handheld sellers during the short sale process, got in touch with the bank, made sure there was a deficiency waiver, et cetera, which is very easy in California and not so easy in other places. But this is, if you're selling in that area, this is going to be a buzzword that we're going to learn, right?
Yep.
Moving on to page 29, small change to the foreclosure bill of rights. And that is it's basically talking to mom and pop landlords. They call them small landlords. You can't own 50 houses. And this is basically a mediation process where you can't be foreclosed upon until the bank has contacted you, try to work it out, et cetera, et cetera. In my experience, any type of voluntary mediation program between the banks and the homeowners doesn't work. They sort of get in there and they do what they have to do. They prove that they tried, and then they foreclose anyways. But this likely is another of the puzzle pieces that we're dealing with, where we have millions of landlords we're told to not accept rent, are very likely facing foreclosure now. So connecting this to the federal overlay from the CDC and the 2 tranches we have of non-payment of rent in California, this is a subject that it's not us. There's nothing we can do, but it's out there and it's going to happen. And there's no way this isn't going to bubble up more. If we have tenant landlords who have not received payments for a year on a rental property and they are running out of savings, we're going to have some foreclosures, or we're going to have some liquidation, right? I mean, the equity is high enough now, but this is something, I just mention it because it's just, you know, the more knowledge we have, the better, but it doesn't really affect our resales. Unless we're contacted by someone who says, I have to sell my house because I'm in foreclosure. And then they'll be in the program and do the mediation and whatnot. Page 34, the homestead was increased to a maximum of $600,000. This is a great bill. Again, it doesn't really affect us. You know, anybody that's owner occupied, owns a home in California should put a homestead on their house. It's one of the best consumer protection things going. It is pennies to record it. And it's really for that end of world scenario. I mean, if you have a judgment against you and they're taking your house, I can't really think of anything, you know, that's top 5 worst case scenario, right? You are losing your home because of debt, because of a judgment that you lost. So it doesn't really happen to a lot of us, but it is out there. But this tool is amazing. Homestead is better than any, for example, if you have a judgment against you, they can only take 25% of your wages, right? If you don't make anything that month, you don't owe them 25%, right? But the way the homestead works, it doesn't even allow a lien or charge against your property. Because if you have a corporation or LLC and whatever, and you've gotten some debts, there's things that can happen where the creditors are not able to come to your assets. They have to wait outside. So if money gets distributed from that entity, then the creditor can grab it. That's why people hide things in LLCs and corporations and whatever. But the way a homestead works is, if you have a homestead and you don't have too much equity, so you meet the criteria, you're under 600, under 300, or you know, it changes from county to county. Actually, it's kind of complicated. So let's just imagine you're in the right amount of equity. Judgment arrives, sticks to your property. You don't have enough equity, it falls away. It doesn't stay there until you get enough equity or until you decide to sell, et cetera. It falls away. It bounces off, which is amazing. You could have a judgment of 500K. You only have 400,000 in equity in your house. The judgment goes away. You sell that house tomorrow, you keep all the money. You take that money, put it in the bank. The creditor can't get that money out of the bank, which is very complicated because they'll try to sweep your bank account, but you'd have to show that that was homestead money. So the bottom line is every single person should put a homestead on their home, and it just got increased to 600,000. A couple of states in the union have no limit. They have no limit at all.
Wow.
Florida,
Darren,
Texas, for example, you can own an $8
Can I ask
million
a
house.
question?
Yeah.
When I was reading on, I actually was reading on this law, and I thought it said in California the homestead was automatic. If it was unless you're like an investor, then you have to say which one. Like if you only own one property, but
You're saying that you don't even have to record the homestead?
I thought that's what the law said, but.
You know, I do not know the answer to that. I thought you had to
Okay.
report. Let me look, let me figure that out and I'll get back to you.
Okay, thanks.
Yeah. So yeah, Texas has no limit. Florida has no limit. That's why you have guys like O.J. Simpson who have $10 million houses and they have a $10 million judgment. How can they live in that house and have a $10 million judgment? There you go. As long as you don't put any money in your bank account, you're allowed to own a car, you can feed yourself, and you can live in a $10 million mansion in places like Texas. That's why it is notorious that who lives in certain states. Like that's why Florida has those people and Texas has those people, because if you're running into a problem and you're going to have a $1 million judgment and you have the wherewithal, you just leave. You leave California, buy a house in Florida, and you're protected. And then, you know, they can get you every time there's a distribution of something you own, but it is a full-time job to go after those guys and get their money after they've sunk the money into the house, right? But I'll look into the homes. I hope that's true. I did not know that. That's just wonderful. But again, the odds of us utilizing the homestead, oh, so terrible. And it's like bankruptcy protection. Sounds good until you file bankruptcy, and then you know it's actually a nightmare. But it's there for consumer protection, whatever. The last one, the only reason it's going to affect us is we always get news late. They've changed the foreclosure law. Can't affect the foreclosure if you borrowed the money for consumer debt. So what in the world does that even mean? So that's going to be like a HELOC. It wasn't purchase price money. You went out and bought a jet ski. You didn't pay the bill back. The bank can't foreclose on your house. They used to be able to. They used to be able to foreclose on a HELOC. So here's where it's going to come in for us. We always check by doing the title search and talking to our clients, you know, what do you owe, what's going on? And what you're looking for is the guy who says, I only have one loan and I'm current and I'm, you know, okay, good. I had another one, but they wrote it off. Never works. These are the guys who are going to be like, yeah, I got a HELOC in 2021 for 50K. I never paid it back. And they wrote it off like in 2022. So it's fine. Wrong. The debt is still there. It's secured. Even if they 1099 them, it'd be a 1099-C, and they sent it to the homeowner and wrote it off. They can unwind that when it comes time to sell. And so what we have to worry about is that second deed of trust that has ballooned into a massive amount of money, and it's potentially all the way to the point of a short sale. This happened over and over to us in the Great Recession, because we had people that firmly believed that they got their first loan taken care of, they got it modified, and they were okay with it, and they built up, and all of a sudden, boom, here comes 2014, 15, 16, and they had all this equity. They're like, great, I didn't get foreclosed upon, I worked a deal out, I can't believe it, now I have a little equity. Or maybe they had an arrangement where they had to pay back the bank something, but they never dealt with the second deed of trust because they believed it was written off. They even got letters to that effect. Then the title company has to call and say, hey, there's a secured deed on here. We need a payoff. And they look it up, and it's owned by 10 banks later, right? Now it's owned by some guy named Harvey in New York City. And he's like, oh yeah, let me check the records. Oh yeah, you owe me $1 million. Why? Well, that 62,000 went to 10% interest, and then blah, 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 blah. So it's massive. And we can't sell those homes. You're in a short sale scenario. So this, when I see that it limits foreclosure in debt, consumer debt, it's like, oh great, that's really good. So we're keeping families in their house. That's good. We don't want people to be foreclosed upon. But really what's going to happen is, in our job, is they're going to tell us the wrong information. We're going to do a net sheet for them and say, hey, it looks like you're going to get about 100 equity out of this with all costs and fees, my fees, everything's going to be fine. Well, there's $100,000 of second deed of trust floating out there that he or she thinks that they got rid of because it was consumer debt, and the banks in California are like, yeah, we can't foreclose on those, so we don't do anything. It doesn't go away. As soon as it's recorded, until it's not recorded, it is there. And we got hundreds of those after the Great Recession, where they thought they were free, and we had to go and do some heavy duty negotiating. It's basically a short sale.
Oh, that's a lot.
That's it.
Oh my goodness, that was a lot more than I was expecting today.
Really? That's funny. Did I talk too long?
No,
Where are we?
no, you're totally fine. Is there anything that's coming up case law wise? Just maybe if you have one thing that you are familiar with that might affect us coming down the line?
I can just tell you about the most recent case I just settled. And it is all about communication. And there's nothing magical to real estate except communicating. And if something it's really hard to have one form that's going to cover everything. When things come up, if somebody's worried about it, that's how we know that it's important. So we just had one where condo stains on the ceiling, and the buyer elected to move forward. The inspector said that's something, something, something. It could be something, we don't know. We said, are you okay with it? Yes, they are. And luckily, we had a good discussion on that. Hey, this came up. The seller doesn't want to replace the whole roof, but you've elected to move forward. Because what would have to happen is you'd have to get a roofer out here, pay them, and get a bid and whatever. And you can do that. You're not allowed to do destructive testing. And that was it. That's all it came down to. Buyer moves in, and in Palm Springs, in March of 2020, we got 0.7 inches of rain from midnight to 3 a.m. in one day. And that caused water to come through and whatever. And as with all lawsuits, not all, the unfortunate lawsuits, the buyer gets in bed with the wrong lawyers. So the entire re-roofing bill was 36 grand. That's brand new roof, which is not fair, because if you're not getting a brand new roof, you're going to get 20 years of life of that. Maybe we would pay for some of it. But his legal bill was 40 grand before we went to mediation.
Wow.
And, and they spent $9,000 on destructive testing. So that's just an unfortunate scenario where a buyer is misled, in my opinion. I don't know how an 81-year-old man can get a $40,000 legal bill and a $9,000 destructive testing bill in good faith. I find that to be outrageous. But, big lawyers, big firm, whatever. Now, our ducks were in a row because we already had that discussion. And then what did they say? Well, we should have talked to more about the house, more about the roof. That's not the standard of care, right? We can't get to the point where we can't allow you to buy the house, right? It can't be our fault that, nope, I'm going to tackle you in the escrow office and not let you sign. That's the standard. It doesn't make any sense. But what I want to point out is there's nothing special about that. But we just pushed all the buttons. We got an inspection. We went over it with them. And then we found an issue, the roof. And we talked to them about it in emails. And we said, this is your option. You can cancel. You can go do more destructive tests. You can do this stuff. Like, maybe we'll get somebody out here and maybe they want to do the roof for you. Maybe, no, I'm fine. It looks good. I believe what he said and whatever. And that's just communication. But you never know which part is going to be the communication. Where's the most important communication going to occur in an escrow? You're never going to know until the red flag goes off, right?
And it
until
always
someone tells you.
The day after they close escrow is when it goes off.
Yeah, and if they say, I'm really worried about mold because my last house had mold and it affected my lungs and it was really upsetting, but this house smells really good. I don't think I need to spend the money on a mold test. Red lights, red lights, red lights, red lights. We're going to get you a mold test. You want to hear a great story that doesn't have anything to do with anything? We had that happen one time. And they said, I dealt with mold and it was really hard on me, but I really love this house. And I think it looks good. And they're saying they don't have any mold issues. And our agent said, you got to get a mold test. No, I don't want to spend the money. I'm going to buy it for you. Thank God. So he buys the mold test, comes back clean. Buyer moves in, has a mold attack, loses her job, so sick, can't go to work. She's a nurse, can't go to work, loses her job. Everything's falling apart. She sues everybody, of course. I get out of the case. I actually paid something, but I think I paid $5,000 or $7,000 because eventually once you get into litigation and whatever. So, we got out relatively scot-free. And they went on their merry way and everybody argued for months and I was out of the case, but it was good. And so ultimately it wasn't mold. Turns out it was tiger urine.
What?
Is that awesome?
What, the Tiger King lived there?
Yeah. So the guy had a tiger and it was tiger urine. And I guess the person had a very crazy reaction to it. like allergic. Unbelievable. But you know what? There's a red flag. She said, I think this house is lovely. And the persons have told me that it doesn't smell bad to me. And he's like, go buy a new home if you're so worried about mold. Nope. I'm going to buy the mold test for you. That's what happened. So that's your lesson in litigation in real estate. There is no way to know what's going on. We just keep our ears open and we pay attention to our client, whatever they're worried about. And if they say, my last house, this happened, and I was really worried about it. It's like, well, let's work on that in this house. Let's ask the inspector directly to go talk about a leaking pool or something, so that and then you can address that with a leak, or a leak detection company, whatever. So I wish I could tell you that there's one thing out there, but that whole case came down to communication. And if I could end with, the future of problems is DocuSign, because our clients are not reading anything.
Right.
At least in the old days, we looked at an addendum and they could see that the swing set was going to stay or not stay. They can't even read it anymore. They're not seeing it on their phone. It's too small. Their eyes are bad. And we're DocuSigning. So you got to communicate better than ever. If you think there's anything that's confusing to them, you want to send them an email. So I just sent you the DocuSign for the form to clarify the swing set is staying with the property. Okay, Mr. Seller? And they say, yeah, I get it. Then now we've documented what in the world that addendum means. I'm getting a lot of, I never agreed to a $10,000 seller contribution. It's like, what are you talking about? It's right here. And we talked about it, because it's too small.
Right.
And so they didn't catch it. And DocuSign is going to take over everything. And you're going to have clients who are going to slow their car down at a stoplight and DocuSign before they take off again, right?
Yeah.
So the odds of them reading the contract before was low. It's getting lower every day.
That is a scary thought. And I always encourage our team at least to say, I'm going to call you on this, or follow up to our conversation. Here's what and
you can blind copy your emails into the system.
Okay.
So when you guys have communications back and forth that the swing set is staying, even though it was a family heirloom, you can blind copy SkySlope and that email gets saved.
No, blind carbon copies don't work on SkySlope. It has to be carbon copy.
Oh, okay. I thought it could be VCC.
Because you just tell your client that, hey, when you see this email address, it's just for my file. I have to the communication log. Usually they don't take it off, or you forward it after.
And emails are your best friend. We never email that we're about to commit fraud or something. That's what we're accused of. You go back 6 months and you look at the email, the client remembers, or is like, oh yeah, that's right. You did tell me that I could do this or that, and I chose not to. 99% of the time, email is our best friend.
Right.
In fact, I haven't had one come up in years where we do anything bad. We never write in, you should not get an inspection. We just don't do it.
Right.
Anyway, thanks for having me.
Thank you so much. Does anybody have any questions before we let Darren off the hook? No?
I'll look up that homestead thing right now. Who was that?
Adrian.
I'll look that up right now, Adrian.
Awesome. Thank you so much. All right. I'm going to quickly go through some things to finish off our meeting. I've got Yvonne on here with Legendary Escrow. Yvonne, are you there? I see your name. There you are.
Yes, I'm here. Can you hear me?
Yes.
Perfect. Okay, so I just have a couple updates to give you guys. The Legendary Escrow NetSheet app is available on the website now. And if you are already signed up with the VAC, in the vendor section for Legendary, if you click on that link, it automatically redirects you to our website to open up orders or check out the tabs or reach out to your escrow officers. The escrow NetSheet app is based off location, so please make sure that you pick the correct location. You're more than welcome to utilize whichever office you would like, but if you're going for a specific location, just make sure that you pay attention to the location, and the next tab will ask you which officer. So if you guys have any questions or concerns with that, or if you're having any issues, please feel free to reach out to me. I will put my information in the comment section. And then a couple other things. We ordered our promotional item for the key tags, which just came in last week. They're laminated and they say Legendary Escrow Services on them. So I will be distributing those out to each Berkshire office. So if you have a transaction that's closing, you're more than welcome to utilize those. I hope they're beneficial for you guys on your transactions. You can give your key to your client. It'll have our information on there. And then just keep continuing to look out for the marketing items that go out weekly. If you have any questions or concerns to those, if you respond to that email, it comes directly to me. If you have any kind of new marketing items that you would like Legendary to put together for you, please feel free to reach out to me. We are here for you. If you have any questions or concerns when it comes to escrow, even for future transactions, please reach out to your escrow office, or you can send me an email. We are here for you guys 24/7. And thank you so much, Shannon, for having me on your call today.
You're welcome. Thank you so much. And next time you pop in the office, can you also drop off some more escrow folders? I think we're almost out.
Most definitely. Yes, I can drop those off for you.
Awesome. Thank you so much.
Shannon, I found the answer.
Thank you.
All right. Tell us, Darren.
It is automatic.
Oh, good.
If you, Adrian's right. If you do file the declaration, it protects you after you sell the property. So if you have a judgment against you and you recorded it and you move the money away, then you're more protected because you've earmarked that money for 6 months after the sale.
Nice.
So again, this is all worst case scenario stuff. For the most part, 100% correct. Adrian's right. You don't have to record it because the judgment will just fall away. You don't have to worry. If you were going to sell right in the middle of it, file the declaration, then that money for 6 months is protected and you can move it out of the bank. Make sense?
Nice.
And
Yes.
I quoted the statute right there.
Got
in the
it.
chat. Okay.
In the chat room. Thank you, Adrian. You're so smart. You always bring those things up. You're always right.
All right. I'll see you guys later.
All right. Thank you. All right. So does anybody have any new listings coming up? We sure could use some. I'd love to hear if some of you have some listings coming. No? All right, so we are still having our Love It or List It contest currently. We only have one person who has done better year over year so far that is going into the drawing. That is Jill. So we have 3 months on this Love It or List It contest. I just wanted to remind you what that looks like. Hopefully I have it right here. The Love It or List It contest, it's for money, 500, 200, or a video book. And we'll do monthly drawings for those that get into the contest. But the only thing you have to do to get into the contest is have an increase in listings taken during these 3 months. So if you did 1 last year, you only have to do 2 this year. And if you did none, you have to do 1. So we're just trying to make everybody do a little bit better, 1 better than last year, and you get to be in the drawing for the 500, 200, or video book at the end of the contest. Super easy contest. I like it that way because I don't want to have to think and take too much time keeping track of everybody. So let's talk real quick about the market updates for the week. We had 114 new listings, and I just decided to look into what's on coming soon. There's 41 hiding on coming soon. So, you know, it's really like 155 listings coming that are new on the market. We had 167 pending, 141 sold, and in Temecula, only single family homes, only 80 homes to sell out here. It's amazing. Everything is down slightly by 10 or 20 or so listings. So that's kind of crazy. All active single family home listings in our 6 city market, only 320 listings to sell. We need listings so bad. So you guys, talk all those potential landlords. If they're leaving their home, make them sell it. Also wanted to remind you, we have lots of floor time available. So if anybody wants to jump on, just either talk to Shauna or jump on Sling. I do want to remind you of a couple of things coming up and an unexpected training I'd like to do. All of you should have got a Valentine's card from me. You saw my special note on my Valentine's card. Last year we did the training for the holiday campaign, but I think we only went as far as February, or maybe we didn't even get to February. But for those of you who need a refresher on how to update your holiday campaign in VAC, I'll be doing a Zoom class on Friday, this Friday at 9:30. So it'll be only about an hour, because once we go through it once, you'll kind of realize, you know, how to get through it. But we'll go through a couple different dates and hopefully you'll take it on to the end. So this Friday, 9:30 on Zoom, I'll send you the link. Also coming up next week, Rick Barabee is doing Success Series, the 23rd through the 25th. It's from 1 to 4. It will be on Google Hangouts. You probably already got a copy of the link, but I'll be blasting it out to you. Mike Ferry's doing listing presentations with Rick on March 2nd. And then you saw me remind you about the national convention to sign up for that. It is free for you, but you have to sign up by March 8th. So that's news to me. That's why I'm telling you. Sign up by March 8th and you'll have your own link to watch from home if you want to. You will get a notice that says, talk to your bulk administrator to see if you're already registered. You're not registered. If you didn't register yourself, you're not registered. So you're good there, with the exception of Donna, because Donna was going to go to convention. She's already registered. Last but not least, our California award banquet, which we're going to be doing via Zoom as well on March 16th. For those of you who feel comfortable coming into the office, I will be hosting it live on the TV, and I'm going to have breakfast brought in. Stephen really wants to cook you breakfast. So I'm gonna be eventually getting a head count for those of you who want to come in when we get closer to that date, but that's March 16th. Last but not least, next week is our Temecula Valley meeting. So all 4 offices coming together. I think we're still nailing down who's our speaker is going to be, but I think we're going to be having Gene Wunderlich coming and talking about the market. And for those of you who've seen Gene talk, he's our government affairs director. He knows a lot. He's, I think, the mayor of Murrieta, or maybe not, I don't remember. But anyway, he's a great speaker, and I hope you guys come. It'll be a separate link, so I'll email it out to you. I'm done. Any other announcements from you guys that you want to announce to everybody else or have questions? Nope. Okay, thank you so much for coming. I really appreciate all of you, and I will send out this recording and Darren's pages that he went over today and that he spoke of. So have a wonderful week.